You've just heard from my colleagues, James and Laura, about how important it is to plan for various eventualities, particularly in relation to divorce or death, and the need particularly to consider these matters in advance and have appropriate documentation in place and arrangements in place so that matters are dealt with in accordance with your wishes. It's important, though, not just to consider the aspects that they've talked about, but particularly to make sure that those arrangements fit in with the company law arrangements you already have in place. It's all well and good having prenuptial agreements, postnuptial agreements, wills, powers of attorney, etc. in place. But if those agreements do not sit and coexist with the arrangements for operating the company generally, and are not in line with those, then they might find that they don't apply and that your wishes aren't actually taken into account. But more generally, the desire to ensure that your company operates in accordance with your wishes is something that should apply just across all situations, not just divorce, death, or loss of capacity. Now, each company and set of circumstances are different. There's no hard and fast rules that apply across all of them, but there are some certain areas that tend to apply more often than not, and those will be the ones that I'll particularly be focusing on. So before I talk about the types of things that you might want to consider providing for in your documentation, what are the documents that we're talking about here? Well, there are two in particular. There's a Articles of Association is the initial starting document that you would look for how a company is run. That's a document that each company is required to have. There's a legal obligation to have one in place, and will set out certain rules and rights regarding how the company is to be operated. But perhaps more usefully and more importantly for our circumstances here is having a shareholders agreement. Now, the advantage a shareholders agreement has, it will often cover similar sorts of issues to the Articles of Association, but it's a private document and therefore is not publicly accessible, and provides a good means by which you can set out rules and regulations you want to apply to your company, but which you might not want everybody else to be able to find out about. So what do we want to cover off in these documents? Well, as I say, there are no hard and fast rules that apply to all companies, but there are two key areas that probably do apply more often than not. Firstly, there's the decision-making process. How are you going to make decisions in relation to your company? How are they taken? Who's involved in those the decision-making process? And who's entitled to block certain decisions from being taken? And then secondly, transfer of shares. Well, that's obviously quite a wide area, covers all sorts of different eventualities, but of particular interest here is whether you want to have some particular restrictions applying in relation to your transfer of shares. Should there be certain categories of individual who aren't entitled to acquire shares in the company? Should there be circumstances in which a shareholder is actually obliged to offer their shares for sale to a third party or transfer to a third party? And we'll look at each of those in turn now, quite briefly. So we start off with the decision-making process. It's perhaps worth just thinking first and foremost, well, what's the general position at law? The general position at law is that with regards to a company, the day-to-day operation of that company and the decision-making process rests with the board of directors of the company. Now, board decisions are generally taken by means of a majority vote, with each director having one vote. Now, that is one vote regardless of the size of shareholding that they might or might not have behind it. So you could have a shareholder or a director who's a shareholder with 80% of the shares in the company, who would have the same number of votes as a director who maybe only holds 5% of the shares in the company. So you need to think quite carefully in your planning as to whether the structure that you have in place at your board level, your decision-making level, is appropriate, and whether those general rules give you the answer that you want when it comes to how decisions are made. Certain things you might want to think about here. Should there be certain specific rights built into your arrangements for individuals to be directors? Should that be linked to a level of shareholding, for example? Should there be certain individuals who, because of their size of shareholding, are entitled to appoint more than one person to the board of directors, so that their control at board level is reflective of their ownership stake in the business? Should certain shareholders have specific rights to veto decisions, so that even though on the face of it the day-to-day operation of the company sits with the board of directors, actually the shareholders or a shareholder shareholder with a certain percentage control might be able to step in and prevent decisions from being taken that they aren't happy with. Now, all of those things, if you want to have them in place, need to be created, because the law itself will not automatically build rights that give you the answers that you want. And that's one of the areas that a shareholder agreement, well drafted, would cover off and provide you some protection with regards to. What about the other aspect then, the transfer aspect? Well, again, just thinking for a moment about the general position. The general position without any other control or protection in shareholders' agreements or in the Articles of Association is that an individual shareholder is free to transfer their shares to whoever they wish, at whatever time they might wish, and on whatever terms they might wish, whether it's to price or whatever. Now, it is true that transfers of shares have to be approved by the board of directors, but the law is quite clear equally that there are very limited circumstances in which the board can block a transfer of shares that on the face of it a shareholder is otherwise entitled to make. So the freedom to transfer shares, whilst is absolutely right and appropriate for large PLCs, for listed companies where that free marketing and transfer is important, absolutely that should apply. But for the smaller family-owned companies, owner-managed businesses, that general ability for shareholders to pass shares to whoever they wish might not be appropriate at all. And you need to think perhaps about a number of questions. Do you want to be able to prevent transfers of shares to certain individuals, certain classes of individuals? Do you want to be able to prevent transfers in certain specific circumstances? Should there be, conversely, circumstances in which a shareholder is obliged to offer their shares for transfer to the other shareholders? Perhaps death, perhaps ceasing to be engaged in the company, be employed or work in the company. And do you want a general obligation that if a shareholder wishes to dispose of their shares, they must offer them first and foremost to the other shareholders of the company at that time, often as a preemption arrangement? Again, as with the decision-making process, it's important to note that unless you build those rights and create a shareholders agreement or articles that encapsulate them, the general position will apply. And the general position may well not accord with your wishes or your desires. So what I'd urge you to do and think about is just consider a number of questions. How do you want your company to run? How do you want decisions to be made and taken with regards to the operation of that company? Who do you want to be shareholders of the company? And by analysing those decisions, you can then start working out and assessing whether or not what you have in place by virtue of the general rules accords with your wishes. And probably more often than not, it won't necessarily do so in all circumstances. And in that case, the key is to be proactive. Look to put a shareholders agreement in place that does satisfy your needs, obligations and entitlements, and generates an arrangement whereby the company is operated in accordance with your desires. As with ever, it's always better to try and resolve a problem before it arises than having to tackle it afterwards.